comments.
Thank you, Mr. Chairman, and thank you for all that you guys do at the Inspector General's office. Mr. Horowitz, thank you for everything. Specifically, when my next questions come on the Department of Justice. Quick question, is the Department of Justice run from the bottom up or from the top down?
I think generally from the top down.
And you're a dependent or an independent agency?
We are an independent agency housed within the Justice Department.
You're no lesser of an attorney than anybody in the DOJ.
I'll let others make that judgment, Congressman.
I think I put your credentials against anybody's from what I've seen. Whistleblower protection. Are you concerned about that?
We're deeply concerned about it, and I'm deeply concerned it's arisen in this context that I've sent the letter today.
Have you seen the protection of whistleblowers get stronger today, or are they less so than, let's say, 2009? And I'm picking that particularly.
Well, we have certainly made efforts to make them stronger, but when you see this action where we are trying to move forward on a whistleblower retaliation allegation and involving an FBI employee, and the FBI wants to first review the documents to see if we're legally entitled to get access to them, that causes me great concern.
Absolutely, and I go back to something your partner right next to you said, trust is a series of promises kept. And to the gentlewoman across the dais saying what happened since 2010, well, there's Fast and Furious, the AP reparations, James Rosen, IRS, Benghazi, it goes on and on and on. Are you familiar, Mr. Horowitz, with slow-walking documents?
We have certainly had difficulty getting prompt access to documents.
Prompt access to documents also supports proper protection for whistleblowers, does it not?
That's correct.
So I'm going to go back to your testimony in September 2014 to this committee. You stated, and I quote, the FBI and some other department components have refused our requests for various types of documents. As a result, a number of our reviews have been significantly impeded. You added that DOJ officials caused significant delays in gaining access to important documents in the IG's review of Operation Fast and Furious. Do you believe that the delays caused by the refusal of the DOJ officials to release documents were intentionally done by some officials within the agency in order to slow down the IG's investigations?
I actually was not the IG back when that all played out before.
But you've seen significant delays.
But I've certainly seen significant delays.
I mean, just like us in those delays, you've seen those delays because it took a Freedom of Information Act to get that information when it was not available to you or us.
I've seen them, and my staff, frankly, has lived them.
Okay. So could these delays and impediments to the investigation into Fast and Furious, which continue today, amount to obstruction in your opinion? I mean, this is not normal course.
Let me just say
this is not normal course of procedure, is it not?
It shouldn't be. Unfortunately, in many reviews, we're seeing it over and over again, and it has impacted those reviews.
So let me go back to this DOJ being top down. So if the Attorney General wants to set an atmosphere of change and compliance, he could he not?
I think across all of the components, that culture that was talked about earlier is critical to set.
And the same thing with this President. He promised an era of transparency, hardly seeing the most transparent administration, period. So even the President could actually expedite this, could he not?
I think there are a lot of people in this process, I agree, that could have an impact by sending a clear message that what happened prior to 2010, which worked just fine, no law changing in 2010, is where we should be.
So you're very familiar with the Vaughan Index, right?
Correct.
So was there anything in the Vaughan Index that really merited executive privilege?
Congressman, I wouldn't opine on that. Frankly, I haven't. I'm familiar with the index. I frankly
Well, once again, it goes to that mindset from the top down. I mean, so when you start seeing private emails being put on executive privilege, I mean, it behooves me that we're not following the law. And the way our system's based is that everybody in good faith upholds their oath to defend and protect this Constitution, to uphold the rule of law. Would you agree?
I agree with that.
So it starts from the top down, not the bottom up.
I think, frankly, it's both the top and the bottom and everything in between that
But,
we've had.
but as an executive, you set the tone. You told me that it's
correct.
run from the top down. So you set the tone from the top. And where responsibilities of aggression are, responsibilities of accountability need to be placed.
You know, we've taken the position from, certainly since I've been there in 2012 with the leadership of the Department, that given the past practice, given how things worked before 2010, there is more than enough good faith basis to send the message that the IG, as the Section 6 states, is entitled to access all of these records. And we've always handled them appropriately. We have never violated any of the provisions in the grand jury secrecy, Title III, et cetera, that are rightly there to protect privacy interests. That has never been an issue. We've done the Hansen review, we've done national security reviews, we've done FISA Amendment Act reviews, we've done Patriot Act reviews. I could go on and on about the sensitive work my office, primarily, as I said, the staff has done for the 25 years of our existence. We've acted responsibly and appropriately. Nothing changed in 2010. And what we need to do is get back to where we were before 2010, when there was a culture of openness and a dialogue that occurred between our office and the components on how we appropriately handle those materials, review those materials to ensure that among the most sensitive information, which is what we are seeing when we're looking at the FBI national security matters, we do maintain that carefully, and we should have that dialogue. But it shouldn't be whether we see it, but how we handle it and go forward.
Mr. Chairman, I just would like to say that this is a very important question for the future Attorney General to be asked poignantly.